Malzberg's Spinning the Law with attorney Kendall Coffee.
Oh yeah, spinning the law, baby. That means tomorrow's Friday. That's the first, I'm sorry, Kendall, that's the first thing that goes off in my mind. Except, of course, if you're in court and you can't make it on a Thursday, then you're here on a Friday, then it is Friday. But this is like almost the end of the show, midway point of the show. Tomorrow is Friday. Kendall's here. All's right with the world.
Mentioning Friday is putting a smile on my face, too, Steve, although you can't see it.
All right, well, no smile, Kendall, and thanks for being here as always. No smile on Lois Lerner's face, I would imagine. She was held in contempt of Congress on a vote that also saw 6 Democrats go along with all the Republicans in the House. And, we've had the Attorney General of the United States held in contempt by this Congress as well. Explain, what that means. We've been through this before, I think. But also, there was a story that I know you saw that the House has the ability to put her in prison if they so desire. Explain all that.
Well, of course, one of the integral functions that the House and the Senate separately have, each have it independently, is ability to conduct legislative investigations. And there have been many, many high-profile, even legendary legislative investigations over the years. So it is a very well-recognized and important function. So what happens if somebody doesn't want to testify? Because they issue subpoenas. And what the position of the House is, and they've relied on some I think, solid precedent to say it, is that they have the right to hold her in contempt, which they have done. It's not anything that the president can review. It's not anything that, in terms of their decision, has to go to the Senate. But the next question is, what are the enforcement powers? Because normally legislative administrative bodies don't actually have the power to put somebody in prison, and that's kind of where the real test is, isn't it? It's one thing to make a finding; it's another thing to actually be able to incarcerate somebody. And there is a history that has established that they can do that through their inherent contempt powers. It's very, very rarely invoked. Normally, any kind of contempt is processed through the courts, but there are cases where literally, for example, the sergeant at arms, the House has certain security functionaries and sergeant of armed personnel could literally come take somebody and put them in a jail. The House doesn't have a regular kind of jail. It would be a local D.C. But theoretically, it could happen. Now, right now, they're not there yet. They're referring it to the Justice Department. But what do we think the Justice Department is going to do with this, Steve?
Nothing.
And so if it's nothing, then I think that the House can and would appoint its own independent counsel, fund it, and could pursue the issues. Her attorney is invoking the Fifth Amendment, and normally the House and the Senate respect the Fifth Amendment. We've seen famous invocations of the Fifth Amendment in front of congressional committees, and they're usually respected. What's different here, though, is that in her first appearance, she did make an opening statement.
Right.
And so House members, House counsels taking the position that, wait a minute, once you open your mouth about a subject, which could be something with criminal implications potentially, you can't then run behind the cover of the Fifth Amendment. You have the legal word we use all the time is you've waived it. You've abandoned it by opening your mouth in the first place.
She
so
got
that's
some bad legal advice, possibly? I
don't know if it was bad legal advice or good legal advice, but I would think maybe risky legal advice, because what you and I have seen over the years is that they get in there, they say, greetings to the committee, and from that point on,
they take the fifth.
They're going to be sure about it.
Yeah.
It's upon advice of counsel.
Right.
We remember baseball players doing
that.
So it's the conventional wisdom is just to invoke the Fifth early and often so that there's no question. Here, she took a somewhat different approach, and we'll see where it winds up.
All right. A big ruling from the U.S. Supreme Court earlier this week, and that upheld the right of local officials to open town council meetings with a prayer. At question was a town council in Greece, New York. A lower court had said that they violated the Constitution by having these mostly Christian-based prayers. But Justice Kennedy, writing for the majority, if I remember correctly, basically said it's really not a religious thing. It's in so much as it's a tradition, a thing, if you will, and keeping with tradition, and that as long as there's an effort made or a sprinkling in of other kinds of prayers from time to time, that there's no problem with this. And it was a 5-4 ruling, and of course you could name right off the top of your head the 4 who dissented.
Well, Steve, you summarized it so well. I don't know what you need me for. I guess I would add a very few things. The U.S. Supreme Court's decision is not earth-shaking in the sense that the court in the 80s had upheld an opening prayer in the Nebraska legislature. And I think just to sort of look down the road where Justice Kennedy is, who's clearly the deciding vote on this, is that if something is ceremonial, if it's intended to invoke the solemnity of the occasion as opposed to religious advocacy, then from his standpoint, and obviously the standpoint of 4 other justices, that's consistent with our Constitution, because our founders did not attempt to erase any mention of God or religion. To the contrary, they viewed an acceptance of God as part of public life. So I think Kennedy and his colleagues are certainly, about where our founding fathers was. Maybe, and in that sense, it's not a decision that should be surprising to anybody. 4 very fervent dissents, but I think we can assume that as long as Kennedy is there and is that 5th and deciding vote, that as long as you don't see religious advocacy in these kind of cases, his view is it's part of our Constitution, part of what our republic was founded based on.
Right, and you're so right about the founders. When the decision came down, Lynn Cheney was here, and she had just written a book on James Madison, and she said even though he believed in secularism strongly still in all, he would have favored this because of, that there were prayers in the White House and everything, and that was, we are a Judeo-Christian nation, and that was the belief of those people back then and there. It's a good ruling, and it's always great. I always take heart when the court rules, any court, but especially the Supreme Court rules, and it seems like a common sense ruling. So bravo for that. Now this I don't like. The court will not rule on carrying guns in public. This centered around New Jersey. They refuse to decide whether the right to bear arms extends to outside the home. They will not consider a challenge to a New Jersey law that restricts residents from having a right to carry. And this would have marked, as they say, the most significant gun control case in the U.S. Supreme Court since the District of Columbia versus Heller.
Well, it's certainly something that could not have been predicted either way. It was one of those questions. It was heading to their doorsteps. I wasn't sure what they would do because for them to accept the decision right now, given the existing jurisprudence, would probably suggest that they might, find themselves, at least 5 of them, thinking that there should be such a right. That being the case, they're not indifferent to the kind of public controversies that are out there, and it may just be that those are seen as sometimes hot, sometimes bubbling waters, and they may not have wanted to jump in right now.
So, not to interrupt, you're saying that they believe you believe they could have thought that if they took it, they might have. I don't know. Was this a was this a full court vote not to hear the case?
Well, it takes a majority to.
Okay.
It takes 4. But here's the point.
Yeah.
They do pay attention to timing. They do not want to create a public uproar or even an undue amount of controversy. So they look carefully at building the law in what they consider to be the appropriate direction. And my reaction to this is that timing just wasn't right from their standpoint, and it might be something that they looked at later. They've certainly dug in on a lot of other controversial areas, and maybe there's like a quota, a super controversial
a controversy quota.
Yeah, Hobby Lobby, and
yeah.
But
what I always find fascinating, Kendall, we only have less than a minute, is that you've enlightened me to the fact that, and maybe it was just ignorance on my part or naivete, that the court does take this kind of thing into consideration. And I didn't. Of course, I know they accepted cases and did not, but you've opened my eyes certainly as to why they may accept and not accept certain cases.
I think there's a very thoughtful process going on that in terms of which cases are accepted, and it's largely based on building, legal principles. But to be a member of the Supreme Court justice and know that the implications of what you say, they certainly are not unmindful of public opinion. Plenty of times they defy it if they think it's a necessary thing to do.
Kendall, always great to talk to you, my friend. Thank you very much. Have a great weekend.
Thank you, Steve. Thank you.
Bye-bye. Kendall Coffee, ladies and gentlemen. Stay tuned for Gimme 5.